Hello, welcome to our weekly COVID update. I'm going to wait a few minutes to make sure that people get a chance to join. I hope you all had a great weekend. Today we want to talk a little bit about green card processing. As you know, every week what I've been saying is that this is the best time to go ahead and get started with permanent residence processing. And so I thought we'd go into some of the nuances and then take time to answer any questions you all may have. So let's go ahead and get started. So as I said, today I want to go over some strategies for permanent residence because there's a lot of confusion as to the job title, EB2 versus EB3. What is it you can and cannot do? And what are some of the pitfalls that you could actually experience if you don't catch those things early enough? So if you missed last week's episode, we talked a little bit about H-1B, the court cases, and the good news that the restriction for F1s not to be able to take full online classes has been lifted. So that was at least I think the only good news we've had for the past couple of months. So if you missed that, you can go to our YouTube channel. And if you haven't subscribed already, please subscribe. And about specialty occupation and what constitutes specialty occupation and how the court cases really affect that. And it's not really a one, here's the answer solution. The strategy has to be all encompassing with the job description and the detail level in which you talk about it and how you relate the education. So, and then, of course, as lawyers, we support it with some precedent with the favorable court cases that have come up recently. So if you haven't seen it, or if you know of someone that is getting an RFE, and we all know that since premium processing has been reinstated, RFEs are up on the rise. And that too, because of the challenges the USCIS is already facing. So please make sure you take a look at it. So immigration pathways. There's the fast track. We're not going to talk about the fast track today. We will do that another day, but we're going to be talking about the standard processing, the processing that most people go through when they are seeking an employment-based process for permanent residence. So we'll talk about specifically, it's all about the job description, and it is processed in stages, and we'll go over that, but actually all the hard work needs to take place up front, even before you started the process. So let us jump to, so first of all, let's talk a little bit about the priority date, because the priority date is, in order for you to be able to adjust status or consular process your immigrant visa, you have to have an available visa number. What does that mean? Well, there's only a certain number of visa allocations that are issued per year. And it is issued per country, and then they're divided up into sub-employment-based categories. But the country that has the largest number of people that migrate to the United States are going to have a queue, a backlog. And remember the way the visa allocation works, it's not just for the beneficiary, but it's counted against the family members as well. There is bipartisan support to try to address the issues we've been having with backlog, but that is what's critical, because you really can't get the benefits of your permanent residence process unless there's an available visa number. Now, the priority date is usually the date that either, if you're going through a standard processing, your PERM is filed with DOL, or if you are going fast track, the date your immigrant petition has been filed. So that's what dictates what your priority date is. So priority date is not your country of citizenship. Somebody may have, you were born in China, but you subsequently got UK citizenship. It's the country of birth that determines your priority date, not your country of citizenship. And they can be both, but it's country of birth. So it's better to keep that in mind. Now, there are various EB means employment-based. There's EB first preference, second preference, third preference, fourth preference, fifth preference. So depending upon the demand within that allocation for the country of birth will determine, what the backlog is. Clearly, if it's a position that, or a category that most people are filing under, then you're going to see a larger backlog. And we'll go over that in just a minute. There is something called cross-chargeability, which means that you can, if you are born in China, let's go back to that example, and China's got a big backlog, but your spouse was born in the United Kingdom, you can use the chargeability of your spouse, it's called cross-chargeability, to benefit your petition. A lot of people don't know that. And it may have probably been helpful if people knew that before they got married. But if you have a choice and you're in one of the backlog countries, this may be a consideration, the cross-chargeability. Then finally, priority date retention. Now, the date your I-140 in an employment-based process is approved, that's the date that that priority date vests with you. What does that mean? That means even if you have to go through the process all over again, you get to benefit from the priority date. Even if you go through a different process, maybe filing with an EB employment-based category that does not have as long of a queue as the one you currently have, you'd be able to use that priority date. So the priority date retention is great, but it only vests with you after the I-140 is approved. And to give you an idea about priority dates, like I said, there's employment-based, so you can see there's first through fifth. It also depends on your country of birth. So as you can see that if you're not from the countries that are listed on one side, was China, India, El Salvador, and so forth, you would fall under this category, all chargeability areas except those listed. So if you're not from one of those countries, then you can see first preference and second preference is C. And C in the chargeability realm is wonderful because it means current. That means if it is a C, then you're able to start your process, and as you go through the stages, you may be able to, because it's usually 3 stages for standard processing, you may be able to file 2 and 3 together if there's a C. So that's actually wonderful because you can get your work authorization much sooner. As you can see for India, it's not looking so great. EB2 is July 8th of 2009, and EB3 is October of 2009. So right now it doesn't seem like there's really much difference, but the way they move month to month does sometimes impact it. And even though EB1 has a backlog, they're suspecting that it's going to become current shortly. Now these numbers are allocated from October to October is when the USCIS fiscal year is. So, usually around October, we'll see that the numbers become current. Now, this is the visa bulletin. This should be your most important reference, and it's found on the Department of State website, and you can actually get it emailed to you as soon as it's issued. The interesting thing about the visa bulletin is it's issued usually 15 days before the next month. And that's been really important over the years. So for example, we've already got August numbers. These are August 2020 numbers. They're not effective yet. They're not effective until August 1st. Why that's important for us to know is, let's say, for example, we were looking at July numbers and there was a category where it was current in July. And then we were able to look at August numbers and we saw that the numbers retrogressed, which means they went back. As long as we file in July, you're still eligible for that classification. And years ago, the Department of State made a mistake and boom, everyone that was in the process was eligible to file. And I have been saying what I'm saying now, that it's important to file, because unless you're engaged in the process, you can't benefit if there's a legislative change or if the Department of State makes another mistake. So it's important to get started in that process. So this is stage 1 with the standard processing. It is with the Department of Labor. Department of Labor wants to make sure that you're testing the employer's testing the labor market, that there are no US workers that are just displaced, and that you're paying the prevailing wage. Recruitment processes that they're required to put forth. But the most critical thing that we do at this stage is we draft the job description. And that's really important, especially given the prevailing wages. I think 3 to 4 months, the prevailing wage is taking, but you may be able to initiate most of the process if you're pretty comfortable with what you think the prevailing wage is going to be before it's issued. Now, one of the things that we do sometimes is we'll file a couple of different prevailing wage requests, just modifying the language, the job description a little bit, so that either way, when it comes back, we're okay. Because the other parts of the recruitment don't require that the salary be posted, which is good. So then after, you go through the recruitment, you have to have the results of the recruitment, and then you file electronically with the DOL. Once that's certified, then you're ready to file for stage 2. Stage 2 is when you're filing an I-140 with the USCIS. So DOL was concerned about, are you displacing US workers? Have you recruited for the job? All the things that labor usually concerns itself with. The USCIS, on the other hand, is concerned about, do you have the education and experience that you're requiring for this job? Can the employer pay your proffered wage? And remember, this is prospective. So it's for future employment. It's not really current employment, and stage 3 is the adjustment of status or consular processing if you're doing it overseas. And if you have a C on your visa bulletin for the category that you're filing, you can file stage 2 and stage 3 at the same time, which is great. And that's why in years past, when someone who was not from, the countries where there's a backlog, all other, and they were worried that they would not be selected for the H-1B lottery, we also started processing while they were on OPT, started processing their permanent residents because, you know, they would be able to get a work authorized status in that time frame. Oops. So at stage 2, all the issues that come up, the beneficiary's education and experience and ability to pay, should have been addressed in stage 1, because you can't make those modifications now. You're stuck. So a lot of people make the mistake of not really, you know, they're just looking at that. We're working on the first stage. Let's just do the first stage. Not really looking at what their client's stage 2 would be like. And, you know, all of that becomes wasted. So it's really important that you strategically look at all the issues beforehand. Let me see. I'm just checking to see if there are any. There's some questions. Let me see what. Get these questions. Does the ability to pay is treated at the time of filing labor? Yes. So your ability to pay, you have to show, the employer has to show that they are able to pay your salary. And I'll tell you how they can do that in just a second. But how they can pay your salary from the date of filing labor till the date of filing the I-140. So that's the time period you have to look at. I'm in a situation when my PERM was filed in October 2019, and it has gone to an audit. It has responded May of 2020. You see, you filed in October. Okay, it's gone into audit. Responded May of 2020. As of May 15th, 2020, I've exhausted my H1. I am now out of payroll and have been moved to B2. Well, so this individual, they filed their PERM in October 2019. It went into an audit. And there can be some reasons, there are some basic audit triggers that I'm going to talk about, which is the strategy portion of you know, what you need to consider when you're filing. But they have exhausted their H-1B 6 years as of May 2020, and they are now moved to B2. Well, number one, make sure that, I'm going to assume that you don't have any buyback time, because if you've got buyback time, you can extend your H-1B for the buyback time is a period of time on H-1B that you were not in the United States. So if you have any of that time, you can buy that back. And if it is not adjudicated by October, you would then be able to change back to H-1B status based on, you know, your I-140 and or your PERM pending for more than 1 year gives you the ability to get those 1-year extensions, not the 3-year extensions that you get if your I-140 is approved, but 1-year extensions. I would like to know, once my PERM and I-140, yes, okay. The individual had a follow-up question saying that, is there some way, I'm assuming that they're saying change status from B2 back to H-1B once the I-140 is approved? Yes, assuming that your B2 was granted, because you have to be in a status in order to change status in the US. And then I would like to know, once my, you know, can I file for the 1-year extension if I don't get my PERM response by 2020? Yes, you can. You can get the 1-year extensions based on a pending PERM for more than 1 year. Either the PERM and or the I-140 or together can be pending for 1 year. Another question is, if the employer pays $100,000 to an employee when filing a labor, does this mean the employer should have a revenue or profit of $100K? That's a good question, Jyoti, and I will explain how that math works in just a second. So we have the evidence of ability to pay there was a memo several years ago that talked about ability to pay. And there's two things. It is the mathematical part, demonstrating the ability to pay. And there's also the evidentiary information that you've got to submit. Now you have to submit, unless the employer has more than 100 employees, then they can have their CFO write the letter. You have to submit tax returns. That's the evidence. I mean, that even if you're not using that as showing ability to pay, you still have to submit your tax returns. The other thing is you can demonstrate ability to pay either one of three ways. That the wage that's stated on your prevailing wage document that's supporting your PERM filing, if the employer's net income per their tax returns is greater than that, then you can show ability to pay. You can show ability to pay by subtracting the short-term liabilities from the short-term assets. And if that is positive, or if that's greater than the prevailing wage, then you can demonstrate ability to pay. And finally, if the employer has been paying the employee the salary, then you can demonstrate ability to pay. And it's not just either or. So in the example we have, the beneficiary is making $131,000 per year, but the prevailing wage is $143,000, which leaves a gap of $12,000. So evidence that the employer has the ability to pay would be, he doesn't have to show that the tax returns have a net of $143,000 because the employee is already making $131,000. As long as the tax returns show a net of $12,000, they would have ability to pay. Now, we have been seeing that if an employer is filing I-140s for multiple beneficiaries, they are now asking to demonstrate ability to pay for all the beneficiaries. They started that, I think the first one I saw was about, 10 years, but it was so rare, 10 years ago, but we're seeing them more often now. So that's something you need to kind of think about. So another thing you've got to prove at the I-140 stage is that the beneficiary has the previous education and experience as outlined in the job description. So if you're stating that you've got the equivalency of a certain degree because you're using a combination of degrees, then I would get that credentials evaluation ahead of time. The other thing that really makes me crazy is I don't even like to file the PERM unless I have the experience letters. Let's say where the position requires experience in .NET. So a lot of times the beneficiaries will tell me, oh yeah, I had 3 years of experience. They'll give me their CV, and I said, but can you get an experience letter? Sure, I can get an experience letter. I said, if you can't get an experience letter, your I-140 is not going to be approved. So I'd like you to try to get that experience letter now. And that really helps in making sure that you don't have any problems. Fast is not necessarily good. Thorough is good. Fast and thorough is good, but thorough is much better than fast. So you want to make sure that you're able to get the supporting documents that, and in that way, if you can't, you can modify the job description. But you can't do that once it's certified. You're stuck. You'd have to go through the process all over again. So the job description. Now, the job description is interrelated to a number of different things. Number one, it's the prevailing wage, employer's experience. You want to make sure that it doesn't hit any of those triggers so that you get an audit, and the labor market. So complex duties increase the wage. Varying from the job description, that the DOL has put in place can increase the wage. Supervisory experience can increase the wage. So you want to kind of, especially keeping in mind, we're trying to make sure that we can meet the ability to pay criteria in stage 2. So how your job description and how the prevailing wage is returned at what salary level will dictate what the employer has to pay. So it's really important that you keep that in mind. Now, once you receive a prevailing wage determination, it's valid for 90 days. And each job description from the DOL has 4 levels. And depending on how you describe the position, it would, and there's actually, if you go on the Department of Labor website, they have kind of a formula that you can use to determine that. Sorry, I'm getting in your face, but I think somebody raised their hand. There's a chat question, and then there's from Prabhu. My visa stamping expired on 2018. If I go to India, I have to go to an in-person interview for stamping. My mother is not well. I have to go to India. What do you suggest? Yeah, well, if you listen to our last week, there has been a challenge on visa issuance for H-1Bs. I don't know, I mean, there hasn't been any change so far, but if somehow a federal judge is able to enjoin the USCIS from implementing this, then hopefully you wouldn't have a problem. But right now, the consulates are not issuing visas. So, I think if you go, and you have to make this decision sometimes, the only other way you could come back is either on an F1 or a visitor visa. And last week I talked a little bit about the concerns I have with that. What you don't want to do is make a representation that you're coming in on a visitor visa and then, and then change status immediately. You can't change status within 60 days of entry, but even after that, you don't want it to seem that you had a preconceived intent to change status. That's why I think the F1 works better, because you'd be able to come back and go to school. And afterwards, you can change back to an H-1B because you won't be subject to the cap. So that may be some thing you want to think about. Hello, Sunanda. Always nice to hear from you. Your question is, one of our family friend came to the US on a B2 visa. His 6-month stay will get over by the 26th of this month. He applied for an extension and it's in process. How long can he stay in the US? Most likely, they're taking so long to adjudicate I-539s that, let's say he's asked for 6 months, it probably won't even be, he probably won't even have a decision before the 6 months is over. But I always encourage people for the unlawful presence issue to, and a number of other things, that he should try to, if he asks for 6 months, he should try to depart prior to the 6 months, even though he can stay here while it's pending. I hope that helps. Another question from Prabhu. My visa stamping expired in 2018. Okay, this is the question we just answered with his mother. And Prabhu, I hope your mother feels better. We were all saying lots of prayers to her and wishes for a speedy recovery. And I know it must be very hard for you. And that immigration should be the last thing that you need to worry about in a time like this. So back to the 4 wage levels. depending upon how the description is crafted, you know, you'll know what wage level it will most likely go into. Now, at the beginning of the process, you want to make sure that you've got the minimum requirements that you're going to require for the position. And remember, this is prospective. So it's not what you currently have. It may be, especially with the backlogs being so long, it could be, you know, a job that you will most likely have down the future. And you want to make sure that your degrees, like I said, you've got the credentials evaluations, you've got your transcripts, and you've got, or you can obtain the experience that you want. So we go through a little chart. We chart out what the person has and what the experience and what the job, you know, requirements are, just to make sure that that's in place. Now, in some instances, not always, you can use experience gained with your employer. It's really tricky. I worry about that. Not so much at the DOL audit level, but at the I-140 stage. So unless I can see, it's got to be, the criteria is it's got to be 50%. The job description that you will be going into has to be 50% different than what you're currently doing or what the experience has. So, you know, sometimes people go into managerial positions. So before they were doing the software development and the work, and then at a later stage, they are not doing the work, but they're managing other people that are doing the work. But they needed to understand how to do it in order to do the managing. So for instances like that, I think it's very clear. But unless it's a clear-cut difference, I won't do the same. I'm going to go through the job descriptions and then I'll answer some questions. So as I stated, you've got to make sure that you have all the evidence. So we talked about how the wage can increase, how the job description can increase the prevailing wage. We also talked about making sure that you've got the background that you're stating for the prevailing wage. And so here's something I wanted to show you. This is the DOL's Wage Library. So this is a software developer for Charlotte, North Carolina. As you can see, there's wages level 1 through 4. And they've got a job description. You should try to stick as close to that job description as you possibly can. You can add a few things, you can expound on it, but when people try to get too crafty with their job descriptions, what happens if DOL doesn't immediately recognize that this is a software developer and they think maybe there's a little something else in there to another, you know, QA or architect or something else. What they will do is they will give you a because they're going to say it's the merging of 2 jobs. So your salary will be through the roof. So I try to keep it simple. You know, you're dealing with, you know, a government bureaucracy. You can't get too creative. So you stick to this and you can enhance it to kind of tailor it to what you're doing, but you got to be careful. And, you know, as you're looking at this, look at the wage levels. Like I said, it's for wage level 1 and 2, you have very little independence. You are directed by, you are advised, you are, you know, you're basically, somebody is telling you what to do. There's no independent thinking as much. So the more the job description sounds like that, the more likely you get a 1 or 2 level. If you are supervising people, or if you have some independent decision-making process or anything like that, then more likely your wage level is going to be assessed higher. The other thing I want you to take a look at and see underneath the description, there's something where it says job zone 4. This is going to be important for another reason. So I want you to remember where you saw that and what the job zone 4 is. Okay. The whole idea of EB2 or EB3, it's not just important to know, well, you know what, before I get into this, let me answer some questions because we're going to delve deep into the EB category. I have a previous I-140 from my previous 2 employers. If I try to file a new PERM with another employer who's ready to sponsor me, though I don't work for him, should I have, no. The question she asked is she's got a previously approved I-140. And she wants to know whether the job description on the previous I-140 has to be the same if somebody else files for her who she's not currently working for. So let me answer that question in 2 parts. Number 1, remember, you have to go through the process again. So the I-140, your priority date vests with you. So you have a vested priority date, which means even though you have to go through the process again, you can use your old priority date for your new process. So that's a tremendous benefit. You still have to go through the process again. So you don't have to use your previous job description. That's question number 1. Question number 2, working for someone, having someone who you are not currently working for file a PERM for you is fine as long as they can prove ability to pay through the net income on their tax returns. Because remember, you're not earning a salary from them, so you can't show that as evidence of ability to pay. So it's got to be either net current assets are greater than the salary offered or net income. So that is something that I would check on before you go forward. Next question. I have 3 years of work experience. Would I qualify for EB2? I have a bachelor's degree. Well, it depends. Number 1, do you have a 4-year degree, bachelor's degree? Because even though, and it's right here on the lock and key, but even though for H-1B, you can use 3 years of work experience for 1 year of degree, in certain countries like India, a lot of degrees are a 3-year degree program. It's ridiculous, and don't ask me why. You can do it for an H-1B, you can't do it for an I-140. You can use a combination of different degrees. Let's say you had a 3-year bachelor's degree, and then you did a master's program, as long as they're accredited programs. And there's a software called Acro Edge that we use. It's the same software that USCIS uses to determine whether schools are accredited. And so whether you would be able to use that in assessing whether you have the full 4-year degree. Assuming you've got a 4-year degree, it's 5 years of progressive experience plus a 4-year bachelor's degree that makes someone eligible for EB2. Like I said, not only do you have to have the qualifications to be eligible for EB2, but the job that you're currently holding has to be one that supports an EB2. And I'm going to be explaining that in just a second. Thank you for answering my previous question. One last follow-up. My attorney states that I will not be eligible for a 1-year extension by October 2020 on the 1-year pending PERM. Yeah, they wanted me to send them some language about how they can extend their PERM by 2020. Why don't you email me and I will try to get that to you. We've had an influx in, probably by the time I finish this webinar, I'll have like 100 email. So I'm trying to get to it as quickly as I possibly can. And so please send me an email and I will try to get a response to you. So you can show that to your attorney. So we've answered these questions, done. And to email me, you would email us at info@challalaw.com, and I'm going to show you that shortly. Okay, so next, so remember how I said it's not just that you've got the qualifications to support an EB, to employment-based second preference, but the job, the job title has to be one that supports an EB2. What do I mean by that? So each job, each job title that the DOL lists has something called an SVP. SVP means, oh gosh, somehow vocational. It's basically the education and experience you need for the profession. I forgot the specific vocational something, but it's basically the education and experience you need for each position. So what they've done is they came up with some numbers and kind of a formula as to how they calculate SVP. So in their calculation, you know, each year of experience on the job is counted as 1 year, is 1 year of experience. But the degrees for a bachelor's degree, they count that for 2 years of experience. For a master's degree, it's the length of your master's degree. So if you have a 3 years master's, it's 3 years, 2 years master's, it's 2 years, plus the 2 years of your bachelor's degree, okay? And that's how you, the experience and the job requirements are in place. So you can't exceed, like for example, you can't ask for more experience if the SVP level says it should be capped at a certain level. What do I mean by that? Let me show you. So SVP, there's level 1 through 9. And as you can see, for SVP, let's go to 7. Over 2 years of experience, but up to and including 4 years. So 4 is the out. So if you've got a bachelor's degree, that's already 2 years, right? And so you can only ask for another 2 years of experience. Otherwise you'll exceed, if the job is a level, SVP level 7. And they interrelate. How do you find the SVP level? You have to go to the job zone first. Yes. So these are job zones. So you remember how when we looked at the software developer for Charlotte, they said job zone 4. So you look at the job zone. The job zone will then tell you what the SVP level is. So that's how you kind of connect the two. You have to find the job zone first. Job zone will then walk you to what the SVP level is. Oh gosh, okay. You can't see it because it changed colors on me, but I gave an example. For example, let's say it's a job zone 3. It'll tell you on the DOL website, when you click on job zone 3, it'll tell you what the criteria is and everything else. And it also say SVP level 6 to 7. Now let's go back. So SVP 6 to 7, that means it's greater than 1 year, but it's up to 4 years. Okay, so what you can't see, because somehow when I cut and pasted these PowerPoint presentations into, it changed the color of my font. But if you do a bachelor's plus 4 years, remember bachelor's is let's say a bachelor's plus 2 years. So 2 years of bachelor's degree, 2 years of work experience equals 4. That's okay, because you've got up to 4 years. So you see how we calculate it? Let me do it again. We know it's a job zone 3. We know that means it's an SVP of 6 to 7. So SVP of 6 to 7 says that you can only have, can be greater than 1 year, but cannot exceed 4 years. So if you're requiring a degree of any kind, you don't always have to require a degree, but if you're requiring a degree of any kind, then you have to say bachelor's degree, which is 2 years, and then the 2 years of experience is another 2 years. So that's 4. You've maxed out. So there's no way that this SVP, a job zone 3, could support a master's degree, because look at this, the font that didn't change colors. Master's degree plus 2 years of experience. So master's degree, assuming it's a 2 years master's degree course, bachelor's degree plus 2 years master's degree is 4 years. And then you're requiring 2 years of experience, that's 6. So you have exceeded the SVP level. It will be audited immediately. And you're gonna have to justify with a business necessity letter. So you kind of wanna look at this ahead of time. And then remember, make sure that your bachelor's degree is equivalent to a US bachelor's degree, 4-year degree. Now, EB2, job zone 4 to 5, support it. SVP level of 7, 8 plus and higher. Computer architects, computer systems computer managers, computer systems analysts, they all support an EB2 petition. It may increase the salary because you're requiring a master's degree instead of a bachelor's degree. And so that will sometimes increase the salary. This is a very good question. What are the application fees combined for all 3 categories the employer will have to pay? Well, the employer doesn't have to pay for all 3 stages. The employer must, by law, pay for stage 1. They've got to pay the lawyer fees for the PERM. They've got to pay for the advertisement, and there's no filing fee for the PERM, but they've got to pay for the advertisement and the lawyer fees. So that's a great question. I'm glad you brought that up. Otherwise, I would have forgotten. But they don't have to pay for the I-140. They don't have to pay for the adjustment of status. So it's only stage 1 that they have to pay for. And if they're ever audited, they would, have to prove that they did indeed pay for it. There's going to be a lot of things coming down the pipeline. The president has said repeatedly that most likely he's going to issue some new executive orders on immigration. He, in fact, said that he is going to revamp immigration through executive orders. So there's going to be some additional changes coming down the pipeline. In addition, the case is being litigated against at least the H-1B provision of the executive order. So, that's going to be very dynamic and changing, but it'll be interesting to see what else is coming down the pipeline. Hopefully if he gets challenged enough, he'll get tired and he'll stop. But if you haven't, please sign up for our newsletter at info@challalaw.com. And remember, our webinar series is every Wednesday. If you enjoyed it, if you found this helpful, when they're not updates, what I'm doing is I'm trying to pick topics that people like you have told me that you want to hear about. If you've got some interest in some topics for next week, email me. I'd love to hear from you, and we'll highlight that. And then I think there's another question. The question is, does the employer have to support with any documentation during the 485? You have to show that that there is a offer of employment. So yes, usually it's we will submit a letter of support, or if you've changed employers, you can change employers. If your I-140 is approved and your 485 has been pending for 180 days, you can change employers, but you have to work in same or similar employment. And there's a new, additional form you've got to file to state that. But yes, there needs to be demonstration that there is still a valid job offer. And the other question is, I don't work for my employer with whom I got the I-140 approved. And if my date becomes current, will I lose my spot as my current employer didn't start the spot? No, it vests with you means it vests with you. We don't know how long, if it gets current, what the only problem would be that it's current. And then after that, it retrogresses. That means there's a backlog again. You don't necessarily lose it, but you would lose the opportunity to file your adjustment because it's not in process yet. But once the I-140 priority date vests with you, there's no time limit on how long you're able to utilize that. So, but it's better to do it sooner rather than later, because like I said, you never know when that window of opportunity is going to come up. So I want to thank you all for joining me today for our webinar. Remember, it's every Wednesday. And if you liked it, subscribe to our YouTube channel. We've got, it's not just that we're telling you what is standard and what you can read on the internet. We're really trying to give you tips and strategies and say, hey, this is the way you should do it. And even if you're using another lawyer, we want to help you. And we're happy to share the information so that your process is successful. So if you enjoyed our webinar, share it with your friends. Well, fantastic. Thank you, Jyoti. Share it with your friends and connect with me on social media. I'd love to hear from you, and stay safe. I'll see you again next Wednesday, and hopefully we can do another one of these informational, and there's not going to be some breaking news that we have to take a deep dive into some other immigration hurdle that's come up. So be safe. And this is Lakshmi Challa. I look forward to talking to you next week. Bye-bye. Oh, there's one other